Okay, so I want you to picture this. The year is 1918. Ashoknagar. You have two brothers. Madhav Prasad, he's a munshi, very ambitious, and he starts up a little grain business.
And his brother, Umrao Lal, joins him a bit later.
Exactly. And they live under the same roof. They're eating from the same kitchen, working the same trade for decades.
If you looked at them from the outside, you would say that is the textbook definition of a joint family.
Absolutely. Socially, it's a perfect picture. But today, we're diving into a Supreme Court case, Bhagwat Sharan v. Purushottam, that shows why that social picture can be, well, financially fatal.
It's a century-long saga, really. We're talking about a massive pile of disputed property and a grandson who's asking a very, very expensive question.
Right. Did just living together and working together automatically make all that wealth joint family property?
And that's the whole mission for this deep dive, isn't it? We have the case files here, and we need to unpack why the court said no. And look at this, this legal landmine called the Doctrine of Election.
It all comes down to a really crucial distinction between family unity and who actually owns the assets.
Right. The plaintiff, the grandson Bhagwat Sharan, he basically argued that because the brothers were so close, because they were inseparable, the business and all the houses they bought were automatically joint. He wanted his cut.
Which, it feels intuitive. It makes sense on a human level.
It does. But the law, specifically Hindu law, is very clear. There is no legal presumption that a joint family automatically possesses joint property.
So you can be as close as anything, but that doesn't mean your bank accounts are merged.
Not legally, no. And the burden of proof, it's massive. It is entirely on the person who claims the property is joint.
All on Bhagwat Sharan, then. He had to prove the existence of what the court called an ancestral nucleus.
I love that term.
It sounds so scientific, ancestral nucleus,
Well,
but really it's just the seed money, isn't it?
That's the perfect way to think about it, the seed. To win his case, the grandson had to prove that the initial capital to start that grain business came from shared ancestral funds.
But it didn't.
No. The records were pretty clear. Madhav Prasad started the business with his own earnings.
So even if his brother joins later and helps the tree grow, if that initial seed wasn't ancestral, the whole tree belongs to the person who planted it.
Precisely. Without that nucleus, the whole argument it collapses.
Okay, but there was a twist in the evidence, right? I saw in the documents that in 1944, the family signed a mortgage deed. And in it, they actually called themselves a trading joint family.
Yes.
I mean, doesn't that feel like a confession, a smoking gun?
You'd think so.
Yeah.
It looks like one. But the Supreme Court saw it as more of a red herring.
Really?
Yeah, they ruled that a single admission in a document can't just override the hard financial facts. If there's no actual nucleus of funds, putting a label on a mortgage deed doesn't magically create one.
Facts over labels. But the case didn't just fail there. The plaintiff made a huge strategic error. He walked right into a trap involving a will.
This is where it gets really interesting. This is the Doctrine of Election. The court even brought out the Latin, quod approbo non reprobo.
You cannot blow hot and cold.
Or my personal favorite.
You can't have your cake and eat it too.
And he was really, really trying to eat the cake. See, years before this big lawsuit, he had actually benefited from a will left by the other side of the family. He inherited a property from it.
Okay, so he gets something from the will?
He does. And he doesn't just accept it quietly. He actively uses that will in a court of law to evict a tenant from that property.
Hold on, so let me get this straight. He waves the will around in one court case saying, this is valid, it gives me rights, so he can kick a tenant out.
That's it. He's approbating it. He's approving it.
And then in this case, when he wants to claim more property, he tries to argue that the very same will is invalid.
The very definition of blowing hot and cold. The court shut that down immediately with estoppel. You simply cannot accept a benefit from a legal document and then turn around and challenge its validity when it's no longer convenient for you.
Wow, it's a brutal lesson in legal consistency. By accepting that one property, he accidentally validated the entire document he later needed to attack.
He completely destroyed his own standing.
So let's distill this. If you're listening and you're maybe in a family business, there are some major red flags here.
Huge ones. First and foremost, never assume we're close means we're co-owners. If you're putting your time, your labor, your money into a family venture, document it.
Don't rely on the joint family label to protect you.
It won't. And for any legal professionals listening, or frankly, anyone dealing with an inheritance, be so careful with this Doctrine of Election.
It's such a quiet trap.
It is. You accept a car, a house, even a small cash gift from a will. You may have just legally barred yourself from ever questioning how the rest of that estate gets divided. Your acceptance and your proof.
Which brings us to a final thought, I think. We all tend to believe our legal position is defined by the big arguments we make in court. But this case, it seems to suggest that your legal reality is actually cemented by the small choices you make, the little benefits you accept, maybe when you think no one's really watching.
Your actions speak much louder than your pleadings.
Thanks for listening to this deep dive.